Good morning or afternoon. I am Stephanie Joy with all things Social Security and Joy Disability. Your video is about to come up, and I just wanted to give a quick reminder that these are casual, off-the-cuff shares during the middle of my In the Trenches workday with my clients. So if you're looking for a CLE from me, those are elsewhere. And if you are looking for a variety show of 45 minutes talking about this, that, or the other thing, you're not going to find that here either. So I hope these help those who are dealing with the Social Security Administration and their claim. Just as these issues affect my clients, they probably affect some of you. Have a great day. Bye. Hey guys, fraud law review. Here we go. This one's a real doozy. This is really bad because I can't stand. I mean, one of my biggest, it's far worse than a pet peeve, is exploiting and conning seniors or vulnerable people who can't, you know, prevent that themselves. This is out of the District of Columbia, the lovely DC. This also is an indictment, not a conviction. So we won't go into any names. However, it is a father-daughter who are charged with a fraud scheme of allegedly exploiting a vulnerable adult. The daughter, I'll say, is 59 years old. Won't say the name because she's innocent until proven guilty. The father is 80. Now, apparently they are from Cordova, Maryland. The U.S. Attorney's Office is the District of Columbia that covers that area. Okay, let's see what these beauties may have done. According to the court documents, going as far back as 2017, so this is not, a real quickie, several years here. These two, father and daughter, Bonnie and Clyde, conspired and engaged in a scheme to deceive the Superior Court of the District of Columbia into appointing them as co-guardians and co-conservators of this vulnerable adult. At the time, the vulnerable adult was 81 years old, 81 years of age, and suffered from severe cognitive impairments that rendered her incapacitated and required that she reside in a nursing home located in Washington, D.C. I get a little confused about how some of this can go on so long under these circumstances, so just take a listen. The vulnerable adult was residing in the nursing home, and these two, father and daughter pair, were required as the guardians and conservators, in part to act as the fiduciaries, of course, and apply the vulnerable adult lady's monies towards her support, care, habilitation, and treatment. Instead, allegedly, these two lovely father-daughter used their authority as guardians and conservators to redirect her Social Security benefits that obviously were intended for, and the checking account funds belonging to the vulnerable to their own bank accounts and for their own benefit. It looks like they took $21,000 in Social Security benefits, which that doesn't seem like that much if it's like a 7-year period. So I'll tell you what I think could have happened with that. And they obtained allegedly over $85,000 from the vulnerable adult's own bank account. And they used it for their personal use. They did not use these funds to pay for the vulnerable adult's care. Now, my question is, the vulnerable adult is in a nursing home because she obviously can't take care of herself. And these two clowns obviously weren't taking care of her. They did so by probably putting her in the nursing home, or maybe that happened close in time. And that's being responsible in theory, right? The nursing home, I would think, would dig and either boot the person out if they're not getting paid long before I think this would happen. Yeah, I think so. or they'd be going to some maybe Medicaid nursing home if she wasn't there already. And that entity accepting the Medicaid patient, I think, would have some clout to figure out what's going on a little bit. But that didn't happen for all these years. So then it makes me wonder if they only took, this is bad, but if they only took 21,000 in Social Security benefits, which is feasibly just 1 year's worth, total 1 year's worth, it could have been just a little bit left over after what had to go to the nursing home went to the nursing home, I'm thinking maybe. So let's say the nursing home does get automatically paid from Social Security, or maybe this lovely father-daughter Bonnie and Clyde team did direct that they get paid whatever minimum they had to, which I don't really get because nursing homes are really expensive. It's certainly way more than Social Security. But if it's being subsidized by Medicaid, that might be different. So were they doing that to keep that off their back while her excess monies beyond that? Then they absconded that with themselves, thinking, well, she's not going to be going out partying, so why not? Don't know. But she obviously had a bit of savings, over $85,000 in her bank account that they took for their personal use. Interesting. Doesn't say here anything about, I don't think, potential sentencing. But the charges were there was 5 counts, which included conspiracy to commit Social Security fraud, theft of public money, conspiracy to commit mail fraud and wire fraud, as well as actually committing mail fraud, and financial exploitation of a vulnerable adult or elderly person, as well as fraud in the first degree against a senior citizen. Well, they know how to throw a lot of charges on there for all the same activity, but all those things really were allegedly violated. So I guess it makes sense. Anyway, that's pretty terrible. Yeah. And then that makes me wonder, was the father who's 80, was he of his right mind? I mean, we know some 80-year-olds that aren't, right? So was the daughter, who's only 59, was she just misleading the father? Was she really doing this and handling it? It'll be interesting. And if so, what should the punishment be if they were both equally guilty and equally intentional? Should they get the same? Should he get less because he's older? 80 years old? What do you think, guys? I can't even think right now, so I'm not even going to give it an opinion. Have a great day. Bye.